3, 2.
Hello everybody, welcome. I'm Ken Katkin. I'm a professor of law at NKU's Chase College of Law. I will serve as moderator of tonight's forum. I'd like to begin by welcoming all of you here in Griffin Hall at NKU, and also everybody who's watching from a remote location. And I'd especially like to welcome the 4 candidates who have graciously agreed to participate in tonight's judicial forum. This forum is co-hosted by NKU's Chase College of Law, the League of Women Voters of Northern Kentucky, and the Northern Kentucky Forum. All 3 sponsoring organizations are nonpartisan. As such, we are hosting this event to provide the public with an opportunity to see and hear from the candidates in the contested races for the state Supreme Court and the State Court of Appeals seats in our region. Tonight's questions have been provided to the candidates in advance. Some questions are specific to the 2 candidates for Supreme Court. Other questions are specific to the 2 candidates for Court of Appeals. And a few questions will be posed to all 4 candidates. The candidates will have 2 minutes to answer each question that is posed to them. Tonight, we will ask only the questions that the candidates have received, and we will not be taking questions from the audience. Just a few more informational matters. In order to preserve the dignity of this forum, the audience is asked to refrain from applauding or otherwise indicating their approval or disapproval of any candidate's answer to a question. There'll be plenty of time for applause at the end of tonight's forum. And also, I must invite everybody to a reception with light refreshments that's going to take place in the lobby immediately after tonight's forum, and everyone here is very much invited to attend that reception. Before I introduce the candidates, please allow me to briefly describe the Kentucky judicial system and the offices that these candidates seek. The Kentucky Supreme Court and the Kentucky Court of Appeals both are appellate courts. This means that trials don't take place in either court. Instead, both courts mainly hear appeals that arise from decisions of the lower courts. Normally, an appellate court will rely on the facts that were found in the lower court. An appellate court almost never overrules a finding of fact that was made by a jury. But appellate courts do take a fresh and independent look at whether the lower court made any errors of law during the trial. In appellate cases, evidence is not presented and juries are not in panel. Instead, attorneys file written briefs and make concise oral arguments that address legal issues the court must decide. During these oral arguments, appellate judges often interrupt the attorneys to ask questions. These exchanges help the judges understand the legal principles of the case and the implications of the various potential decisions they might reach. Because appellate courts focus on questions of law, they have the authority and the primary responsibility to say what the law is. Their interpretations of Kentucky law become precedents that are binding in future cases. And because the meaning of Kentucky's Constitution and its statutes often are contested, Kentucky's appellate courts play an important role in constructing the law of our Commonwealth when they resolve disputes about the law's meaning. The Kentucky Supreme Court was created by a 1975 constitutional amendment and is the highest court in Kentucky. Until 1975, the Kentucky Court of Appeals was the only appellate court in Kentucky. The Kentucky Court of Appeals is now Kentucky's intermediate appellate court. This means that normally a lower court's judgment must be appealed to the Court of Appeals, and the Court of Appeals cannot pick or choose its caseload. Instead, ordinarily, it must decide every case that's appealed to it. Some cases, however, bypass the Kentucky Court of Appeals. Criminal appeals involving sentences of death, life imprisonment, or imprisonment of 20 years or more are appealed from trial court directly to the Kentucky Supreme Court, and the Supreme Court must hear such appeals. In contrast, other types of cases reach the Supreme Court on a discretionary basis, on appeal from the Kentucky Court of Appeals. This means that accepting those serious criminal cases, the Kentucky Supreme Court gets to decide what cases it wants to hear and what cases it doesn't. If the Supreme Court opts not to hear a case, then the decision of the Court of Appeals in that case stands as final. The Supreme Court of Kentucky is the court of last resort and the final interpreter of state law. It consists of 7 justices who are elected from 7 appellate districts, and each serve an 8-year term. The Chief Justice of the Commonwealth is chosen by his or her colleagues, and serves a term of 4 years. The justices hear appeals of decisions from the lower courts, and they issue decisions or opinions in those cases. But also, in addition to hearing appellate cases, the Kentucky Supreme Court also is responsible for establishing rules of practice, procedure, and evidence for Kentucky courts. Through its sub-agencies, the Kentucky Supreme Court is also the final arbiter for bar admissions and for disciplining attorneys who engage in unprofessional conduct. So that's just our overview of really what the jobs are that these candidates are running for. I will now introduce our judicial candidates. The biographies that I'm about to read are brief and were edited from information that was provided by the candidates. So I'm going to start at stage right. Our two candidates for Northern Kentucky's seat on the Kentucky Supreme Court are on stage right. That's Joe Fisher. Mr. Fisher resides in Fort Thomas with his wife Karen. They have 2 adult children and 3 grandchildren. He's a lifelong member of St. Catherine Catholic Church and licensed to practice law in Kentucky and Ohio. Mr. Fisher has litigated cases before the Kentucky and Ohio Supreme Courts, including successful challenges to the Commonwealth's redistricting laws. Mr. Fisher has served as a member of the Kentucky General Assembly since 1998. As a legislator, Mr. Fisher is the author of Kentucky's Trigger Law and its Yes for Life Amendment. Mr. Fisher is a candidate for the Kentucky Supreme Court. The other candidate for the Kentucky Supreme Court, sitting right next to Joe Fisher, is Michelle Keller. Michelle Keller worked her way through NKU Chase College of Law as an intensive care nurse. After a successful law practice, she was elected to the Court of Appeals and later appointed and then elected to the Kentucky Supreme Court. Ms. Keller was the first woman to hold both of those seats. She's chair of the Kentucky Access to Justice Commission and of the Criminal Rules Committee. In 2020, the Kentucky Bar Association awarded her its Distinguished Judge Award. Ms. Keller and her husband Jim, a physician, have 2 adult daughters, and Ms. Keller is a candidate for the Kentucky Supreme Court. On stage left are the candidates for the Kentucky Court of Appeals from this district in Northern Kentucky. And so immediately next to me is Suzanne Citrullo. Ms. Citrullo is a 1984 graduate of NKU's Chase College of Law. She was admitted to the bar in Ohio, Kentucky, and all federal courts. She was a staff attorney for the Kentucky Court of Appeals and worked for 2 area law firms before forming Citrullo Law with her husband in 2001. Ms. Citrullo has lectured extensively, represented hundreds of adopted families, is a certified mediator, and a community volunteer. Recognized as the most distinguished lawyer of 2021 by the Northern Kentucky Bar Association, she was appointed last year to serve on the Court of Appeals, and Ms. Citrullo is a candidate for that seat on the Kentucky Court of Appeals. Ms. Citrullo's opponent sitting on the end there is Bob Winter. Mr. Winter likes to say that he is a Kentuckian by choice. He was born in Pittsburgh and served in the Navy, where he was awarded the Navy Achievement Medal. He graduated magna cum laude from the Brandeis School of Law at the University of Louisville. Mr. Winter practiced law for over 38 years and has had the opportunity to practice in virtually every area of law, including being the city attorney of Park Hills for 38 years. In the last 5 years, Mr. Winter has litigated approximately 160 appeals in Ohio and Kentucky. He lives in Edgewood with his wife Deanna and a stepdaughter Hannah, and Mr. Winter is a candidate for the seat on the Kentucky Court of Appeals. So that's what the job is. That's who our candidates are. And now it's time to start asking the questions. So the way we've got this organized, I've got some questions that are for the Supreme Court candidates, some questions that are for the Court of Appeals candidates, and then a few questions that are for everybody. And what I will do is alternate back and forth one question at a time between the Court of Appeals candidates and the Supreme Court candidates. You've got the same number of questions for each, and then that'll take us to the final questions, which are for everybody. So I will start with the Court of Appeals, and I will start first with Mr. Winter. And the first Court of Appeals question: judges play a role in ensuring the efficient operation of courts. What suggestions, if any, would you offer to improve the administration of justice in the Commonwealth?
My experience in ensuring efficient operation of court stems from my clerkship with our federal district court judge, William Burleson. And there were two ways that he would ensure administration of his office. The first was internal. There would be meetings of the staff weekly, and each case would be reviewed, including any problems, any strong points, any review of deadlines that were set internally were reasonable or need extended. That way, the goal of ensuring that cases are properly ruled on, properly and timely ruled on. That's the goal that we all have, is to get decisions out the door, and so that the litigants can pursue their lives, whether they be further litigation to the Supreme Court or let the decision lie. The second tool that was used in ensuring proper administration and efficient operation of the courts is, in fact, a computer-generated report by the Administrative Office of the Courts that is submitted to the Chief Judge as well as each judge within the district. And that shows cases that have been adjudicated, both in terms of name and number, and also cases that have been under submission, or decisions, I should say, are under submission for, I believe it was 6 months. And that would call attention to the judge as to issues that he may or she may not be aware of, and take the matter under submission. Again, the goal is to move the cases along, get decisions. What's the tune? Okay, well, I'm about done. The goal is to make sure that the cases move along. These are the two tools of management that we can use to ensure that the courts are efficiently managed.
Thank you, and I'll ask the same question to Ms. Citrullo. Judges play a role in ensuring the efficient operation of courts. What suggestions, if any, would you offer to improve the administration of justice in the Commonwealth?
Well, the short answer to that is I would recommend that voters elect judges who have a proven record of being very efficient. Obviously, in my court, I'm very proud of the fact that we have kept up with all of our cases despite a campaign year. And I do have a proven record of being efficient. As a trial attorney, as a busy mom, as a small business owner, I have a reputation that I make sure that I'm on time. I didn't ask for more time when I was a practicing attorney. I'm not asking for extra time to make sure that things get done in a timely fashion. But overall, I think the public does have concerns on occasion about the delay. Some of that is inherent in the rule process, the motion practice. That builds in some time that everybody wonders about. I know when I was a practicing attorney, I had clients that sometimes did just want a judge to rule, even if it wasn't in their favor, so that they could get on with their lives. Nobody likes to be kept in limbo. So we do need to make sure that we rule not only properly, but efficiently and promptly. In my trial experience, I also represented hundreds of families and children who were going through the foster care program, and in termination of parental rights cases, children are often in limbo for 2 to 3 or even more years before it gets to the trial court. That makes a big part of our docket in the Court of Appeals, those kind of cases. And so my experience and my knowledge of how important it is to get that finality to those families has served me well in the past year in ruling on those cases very promptly. We also need to make sure as a court, the overall system, that we have staff that is paid, to clerks and support staff that is paid so that we can compete with the private sector. Because again, justice will be delayed if we can't efficiently throughout the legal system, have people that care and are concerned about doing the right thing and moving cases forward. Thank you.
And I should have told this to all the candidates earlier, but we get a signal and there's 20 seconds left. So now and I apologize for not telling that to you guys first. So now we'll move on to the questions. First question for the Supreme Court candidates, and I'll start with Ms. Keller. The Kentucky Constitution requires that judges in Kentucky shall be elected on a nonpartisan basis. What values are promoted or diminished by the requirement that judicial elections must be nonpartisan?
Thank you, Professor Catkin. You mentioned the judicial article in your introductory remarks, and in that article, our Constitution was amended, our state constitution, to call for many things, a unified court system, and maybe most importantly, the nonpartisan election of judges at every level of our court system. We take an oath to abide by both the United States and Kentucky constitutions. And so I personally feel that part of complying with my sacred oath is certainly applying the Constitution to myself and my duties on the court presently and in my conduct as a candidate. It's vitally important that we keep our courts nonpartisan. Lady Justice is blind for a reason. Everyone should be equal in the eyes of the law. You should not be separated by race, gender, color, creed, sexual orientation, or political party. And judges in courts at all levels are called on to be umpires, to call the balls and strikes between whatever litigants are in front of them. And sometimes the litigants are partisan political actors, and especially at the Supreme Court, where I sit, sometimes the litigants are the other two branches of government. So if our judges and justices are not nonpartisan actors, truly running in a nonpartisan way and adjudicating in a nonpartisan way, the impartiality and independence of the third branch would be called into question. The third branch is the check and balance, and for that reason, a vital part of our democracy, both here in Kentucky and nationally. I call democracy a three-legged stool, one leg for each branch. Should the third branch fall to partisan political persuasion, then a leg on that stool will fall as well, and our democracy will be threatened. That's how important it is. Section 117 of our state constitution. Thank you.
Thank you, Ms. Keller, and now I'll ask the same question to Mr. Fisher. The Kentucky Constitution requires that judges in Kentucky shall be elected on a nonpartisan basis. What values are promoted or diminished by the requirement that judicial elections must be nonpartisan?
Well, frankly, I don't think that ethical values like fairness or impartiality are diminished or enhanced by nonpartisan elections. Across the country, we see that 8 states have partisan elections for judges. 14 states have nonpartisan election for judges. There's really no empirical evidence of bias in states which elect judges on a partisan basis or nonpartisan basis. But there is value, there's political value in having an informed electorate. It's not up to the Kentucky Supreme Court or the Judicial Conduct Commission to decide whether nonpartisan elections are good or bad. Their policy preferences are irrelevant. At Section 117 of the Kentucky Constitution states totally that the judges shall be elected on a nonpartisan basis as provided by law. Judicial commissions don't write laws. Legislators do. So what has the General Assembly said about nonpartisan judicial elections? Basically, KRS Section 118A says that the General Assembly has decided that the nonpartisan character of judicial elections shall consist of placing names of judicial candidates on the nonpartisan side of the ballot. That's all. The law places no restrictions on nonpartisan candidates disclosing their party affiliations. And that's really what voters want to know. So if the Judicial Conduct Commission wants to impose tighter laws to restrict the partisan affiliations of judicial candidates, they should ask the legislature to change the law. Besides, the Sixth Circuit has made it clear that the First Amendment to the U.S. Constitution protects the right to disclose party affiliation in nonpartisan elections. And I'll continue to follow the Constitution in this matter.
Thank you. I think I'm just going to reverse the order now on the next question. So if Mr. Fisher doesn't mind, I'll start with it this time. So the next question, I'll do the next Supreme Court question, and that is Kentucky's state constitution includes an express constitutional right of seeking and pursuing happiness. When interpreting this provision, Kentucky courts have led the nation in recognizing individual rights of privacy and autonomy, sometimes long before the U.S. Supreme Court has recognized similar rights. What methods would you use to interpret the meaning of our state constitutional right to seek and pursue happiness?
Well, that's a great question. I would describe my approach to constitutional interpretation as both textual and originalist. Like Justice Scalia, I believe that you give the text of the Constitution whatever meaning it had when it was adopted. So the real question is, what did the phrase right of seeking and pursuing happiness mean when our Constitution was adopted in 1891? Did it mean the same things that did Jefferson in 1776 or John Locke in the 1600s? He coined the phrase. Locke and Jefferson usually echoed the Greek philosophers. In Greek, the word for happiness meant a state of being built upon morality and virtue. In their view, humans achieve their peak happiness by living a life, a moral life, full of virtuous acts. Locke wrote that the foundation of liberty is built on the need to pursue happiness. Like the Greeks, he believed that the pursuit is not the satisfaction of personal desires, but to achieve the greatest common good performed by free choice of the individual. And unless the original meaning of the phrase pursuit of happiness somehow changed between 1776 and 1891, I apply the original meaning of the meaning to the facts of a privacy claim, even if the application of the original meaning contradicts prior decisions of the Kentucky Supreme Court. And I'm not the only one who looks at it this way. Justice Thomas recently made similar comments about prior decisions of the U.S. Supreme Court on the issue of privacy and autonomy, because they may or may not exist in the U.S. Constitution.
Thank you. Mr. Teller, I'll ask the same question. Kentucky's state constitution includes an express constitutional right of seeking and pursuing happiness. When interpreting this provision, Kentucky courts have led the nation in recognizing individual rights of privacy and autonomy, sometimes long before the U.S. Supreme Court recognized similar rights. What methods would you use to interpret the meaning of our state constitutional right to seek and pursue happiness?
First, let me say this question is slightly touched on pending cases, so I'll be very careful how I answer this question at this forum. But I would approach this constitutional question as I have any other constitutional question that's come before the court. And first, that's the plain reading or meaning of the text. Our Constitution was written in 1891, and parts of it are very straightforward and plain, clear and easy to interpret. For those provisions which may appear to be more vague or ambiguous to a judge, then a judge or justice would refer to the framers' intent of our 1891 Constitution and or the prior precedent of our own court, because stare decisis is important. We have a great resource in our state law library in Capitol that I've used on many occasions when I have found the plain reading to be somewhat ambiguous and needed to understand what the framers' intent was. And you can honestly read the entire debates from 1891 between the various parties and who made them. And that's of great assistance to any judge. Additionally, we have well-developed precedent from our state Supreme Court that we can refer to. and we are reluctant to overrule that precedent without good cause. I've been sitting on the Supreme Court for nearly 10 years. When we approach overruling precedent, it is a lengthy and very detailed discussion that is not done quickly. So that is something that we take very seriously. The last thing I want to add is that our state constitution has the strongest separation of powers in the nation. There's only 2 other state constitutions that equal it. So the judicial branch's part of this interpretation is incredibly important.
Thank you. Okay, I'll move back to the Court of Appeals candidates with a question. This time I'll start with Mrs. Trullo. Either as a judge or as a lawyer, you've been involved in civil or criminal jury trials. Please describe the role of juries in our system of justice, perhaps strong examples from cases in which you participated.
Thank you, Professor. The role of juries cannot be emphasized enough. Juries are so vital to our system of justice. They provide the framework by which we evaluate claims, compensate wrongs, and in criminal cases, of course, they determine guilt and recommend punishment for those who committed illegal acts. I'm proud of the fact that I tried a lot of cases to juries over the years before I became a judge on the Court of Appeals. I was recognized as one of the most prolific trial attorneys in the Commonwealth at a time when women weren't doing a lot of litigation work. So I really treasured juries. As far as an example, one of my favorite stories about trying a case with a jury was a case that I tried for civil damages out in Boone County. And in jury selection in a civil case, attorneys will often ask the jury, if I show that my client was injured and is entitled to compensation, would you be comfortable awarding a lot of money? And one of the jurors, a young man, asked to approach the bench in response to that question. So we all went up to the judge, and the juror said, Your Honor, I just work part-time delivering pizzas. I don't have a lot of money to give. And what that told me is that we have to recognize that even though jurors try to get out of service sometimes, and they may complain when they get called, they really do take it seriously, and that's why they're so important. And we need to make sure as a legal community that we encourage juror service, because that gives us really our community values, and it's just extremely important that we give attorneys the opportunity to try cases in front of juries as well.
Thank you for that, and I will ask the same question to Mr. Winter. Either as a judge or as a lawyer, you've been involved in civil or criminal jury trials. Please describe the role of juries in our system of justice, and perhaps strong examples from cases in which you participated.
The role that our juries play in our system is that they're the conscience of our community. They hone and refine the facts that the attorneys are able to get before them and make factual decisions. And the attorney who's thinking about taking a case to trial, they better realize the threshold that the jury has in making these decisions of fact. He must sift and weigh his evidence that he plans to introduce, and she must decide the risks and hazards of doing so, and what the opposing counsel and opposing party will also do. If you decide to try the case, then try the case, but recognize that there are hazards there, because the jury is the conscience of the community. 2 cases that quickly come to mind when I read that. The question was the case out in Boone County. It was a great case, just great. We should have won, slammed that plane all over the courtroom. But you know what happened? My star witness came across to that jury as a KGB commandant or a SS officer. My gracious, it was awful. And we went right down the chute. And We just didn't overcome that threshold of risks and, you know, what the jury would think about this key witness. On the other hand, I tried one where the client just said, risks be, you know what, full speed ahead. Being a naval officer, I like that kind of talk, but it was risky. And lo and behold, the jury came back on my side for liability. Never thought it would happen. They're the conscience of the community. And thank goodness we have constitutional protections for our jury, and that we use them. But we attorneys have got to be careful when deciding whether to take a case to trial or not.
I think I'll go back to alternating between courts, so I'll go back to the Supreme Court now, and I think this time it's Keller's turn to go first. Supreme Court justices often write dissenting opinions, and you may find occasion to do so. Who do you see as the audience for written dissents?
Well, the first audience for dissent that I might write are my colleagues on the court, because I'm trying to persuade them to see it my way. And there's nothing more satisfying as a jurist to be able to sway the majority of the way, and sometimes cases do flip within the conference room before they're rendered. So that would be the first audience. The second audience is, of course, the United States Supreme Court, because they're the only court that can really grade my homework. And I'm always thinking about an important legal principle, something that I feel strongly enough to write a dissent about, may eventually make its way up there, and maybe someone will be listening. So that's the second audience. Dissents are really important because they give you the example of Kentucky's Justice Harlan, who wrote the dissent in the famous case of Plessy v. Ferguson that became the legal reasoning that Justice Thurgood Marshall used, who was an attorney arguing before the U.S. Supreme Court, and the majority adopted that analysis for the landmark case of Brown versus the Topeka Board of Education. So that's how important one justice's dissent can be. He was the sole dissenter in that case, and had the courage to be the sole dissenter. So I've been fortunate to be the sole dissenter. I've been fortunate to be a dissenter when it's two of us, and I've been fortunate to be a dissenter when it's three of us. But if it's important enough to hold dearly, then it's important enough to write it out. And perhaps maybe the most important audience are the parties themselves and their counsel. They need to understand that the entire court took a good look at both sides of the question, turned it inside and out, and gave it its due. And so sometimes I'm writing to let the other side know we looked at this carefully, or how it might be better approached in order for their analysis to prevail the next time. Thank you.
Thank you. And now I will ask the same question, Mr. Fisher. Supreme Court justices often write dissenting opinions, and you also may find occasion to do so. Who do you see as the audience for written dissents?
Well, I have to tell you, before I decided to run for the Supreme Court, I spoke with other judges about this race. I previously served in the minority in the General Assembly, and frankly, I wondered whether I'd be more effective staying in the General Assembly now that I serve in the majority. One judge came up to me and said, "Joe, never underestimate the power of a well-written dissent. Even if you are in a minority, your dissenting opinions will keep the law unsettled until the old liberal majority is replaced." So he reminded me about what I did while serving in the Republican minority in the House. He said, "You were the first to sponsor right to work, repeal the prevailing wage, advocate school choice, defend life long before your party took control. Those policies were all eventually adopted when the Republicans took the majority. So you can be a leader on the court, even while you're in the minority." I also take encouragement from the story that appeared in this month's bench and bar about Justice Harlan's dissent in Plessy versus Ferguson that paved the way for Brown versus Board of Education. And I also recall Judge Byron White's dissent in Roe v. Wade. when he called the majority decision a raw exercise of judicial power. Those simple words gave pro-lifers encouragement for 49 years, until it became a majority rule this June in the Dobbs case. So I suspect that the audience for my dissenting opinions will be people who care about the actual text of the Constitution, those who are concerned about the current imbalance of power in the branches of our state government, and the people who share the belief that courts should not legislate from the bench, but follow the laws of the Constitution as it's written. And I trust these folks will hold me accountable for all my opinions, whether in the majority or dissent.
Thank you. And now we can go back to the Court of Appeals question. I believe it's Mr. Wender's turn to go first this time. So the next question is, what can be done to provide adequate access to the courts for all citizens? And in particular, should any specific changes be made?
Thanks. When I read this question, two things immediately came to mind. The first came from my naval experience as a supply corps officer on the submarine, and that is, you've got to take care of the sailors, and you've got to take care of the clerks. And what I mean by that is do everything we can through the budgetary process to ensure that they're adequately paid, make sure they're adequately trained to serve our citizens. So when a citizen comes to the window and asks the inquiry, that deputy clerk will have the training to respond and give a good answer. And frankly, paid well enough and motivated enough to do so. The second thing that came to mind was making sure that the attorneys and our citizens have access to court records. And since I've done about 160 cases recently, that's really important to me. I think one of the best court systems, electronic systems, is now Supreme Court. You can just, once you figure out how to do it, in all fairness, you're in that system. You can pull up a brief, pull up a decision. It is just super easy, friendly for both the citizens and the attorneys. So those things immediately come to mind. Make sure that our clerks are well-trained, well-paid, and motivated to serve our citizens. And second, we'll make sure our electronic filing systems are easily accessible to both the bench, the bar, and most importantly, all our citizens.
Thank you. And Ms. Trill, I'll ask the same question to you. What can be done to provide adequate access to the courts for all citizens, and particularly should any specific changes be made?
Well, I don't really have any specific changes I think need to be made right now. The Access to Justice Commission was established, I believe, in 2010. Justice Keller chairs that now, so she can answer this better than I. But since then, we have just done so much to provide access to all through a lot of things that Chase does. We have so many clinics for veterans and homeless, and the mental health clinics and specialty courts that we have in place now have done a tremendous job in that regard. Living here in Northern Kentucky, we are so blessed as well to have a tremendous legal aid society, Legal Aid for the Bluegrass, and they've been around for a long time, making sure that everyone who needs access to the courts is able to get an attorney and be represented. The Children's Law Center is one of my favorite organizations here locally, and they do a tremendous job of making sure that everyone who needs access to the courts in regard to matters involving children can get that help. Our Northern Kentucky Bar Association, which I've been very involved in, has been very active in making sure that private attorneys, as I did before I went on the bench, step up to help fill that void and make sure that everyone can get an attorney when they need representation. So I don't know that we need to make a whole lot of changes, sometimes when you do make these agencies that provide the resources to fill the need, you just have to work harder to communicate that those resources are there. And that's where I think the courts become very important, and that we can communicate to the public that these resources are there so that everyone can have justice under the law.
Thank you. Okay, now back to another Supreme Court question. I think this time Mr. Fisher's going to go first. A Kentucky statute provides, and I'm quoting from it now, that all statutes of this state shall be liberally construed with a view to promote their objects and carry out the intent of the legislature. In light of this statute, what role should materials other than statutory text play in the interpretation of Kentucky statutes?
Well, this particular statute is KRS 446080. It purports to tell judges how to interpret laws. Of course, lawmakers cannot tell judges how to interpret laws. So I regard this statute really as having no binding effect on the way judges do their job. In fact, the Kentucky Supreme Court's doctrine on juror rights has effectively negated the second part of that statute, which states that the rule that statutes of derogation of common law are to be strictly construed shall not apply to the statutes of this state. So in my view, judges are free to interpret the statutes liberally or conservatively. As Justice Scalia used to say, I don't interpret laws strictly or sloppily. I interpret them reasonably. So in Kentucky, it's up to the people every 8 years to decide whether judges have ruled reasonably. And as a judge, I will construe statutes reasonably based on their text. Here's why. As a legislator, I have written, rewritten, and amended hundreds of laws over 24 years. And experience tells me that it's the text of the law that best reflects the intent of those who voted for it. Each legislator has its own individual reasons for supporting a particular piece of legislation. More than once, I've had colleagues come up to me and say they hated my bill, but voted for it anyway because I had voted for their bill. No panel of judges can discern the diverse intentions of every legislator just by referring to the public record of a few comments by the sponsor. The text of the law really is the best evidence of intent. Of course, if the text of the statute contains an obvious scrivener's error, the court should step in and correct the problem. For the most part, judges should interpret and apply the statute as written. That way, we respect the consensus intent of the entire General Assembly.
Thank you. And I'll ask the same question to Ms. Keller. A Kentucky statute provides that all statutes of this state shall be liberally construed with a view to promote their objects and carry out the intent of the legislature. In light of this statute, what role should materials other than statutory text play in the interpretation of Kentucky statutes?
Other materials only come into play when the text of the statute is ambiguous. And sometimes the meaning in text is clear, but sometimes it's not. It is ambiguous. And at those times, courts for hundreds of years and our current court will look to other ways to help interpret the meaning. First, we're going to presume that the legislature meant what it said and said what it meant, and that all parts of the statute work together, and that it should have a constitutional result as well as not have an absurd result. So we look at all of those different factors when analyzing the statute. We only need to go to other states' precedent or other academic sources like law journals or other academic writing if, after we've exhausted all those pathways, we still are in quandary. But we must remember that those other sources are not. They are not precedent for our court, they're merely persuasive. So our Kentucky Supreme Court Court of Appeals has 200 years of precedent. as well as a view towards harmonizing the words in the statute to have meaning where that statute sits within the context of all of our statutes. And what I mean by that is there may be a chapter on workers' compensation. There may be a chapter on deeds and other writings. There may, all the different chapters that can exist may have a preamble with language that gives us guidance, but we certainly want to interpret the statute so it fits within the chapter where it's found. So we use all the tools that I have described, as well as the plain meaning of the words that are clear.
Back to the Court of Appeals question, and I believe this time it's Ms. Trillis trying to go first. As a member of the three-judge panel, how will you work with the other judges when one or both disagree with your opinion in the case?
Well, I'm really glad you asked that, because I think it's important for the public to understand that we are an unusual court. We do sit in panels of three. There's 14 total judges on the Court of Appeals across the state, and we decide cases across the entire state. But every month we're with 2 different judges. So I've had to work with the other 2 judges on the panel for over a year now. And it does require the ability to communicate well with the other judges, to explain your position, and to ask questions without being critical. And I think those are skills that I've brought to the table. While we all are we're diverse, we're actually 7 women and 7 men right now on the court, which I think is a perfect split. But we all bring different backgrounds and experiences to the court. And I've been welcomed on the court by the other judges because I've had a lot of trial experience. And, they said we're reviewing trial proceedings, so that experience is important. I've also had a lot of family law experience, which, as I said earlier, is a big part of the cases that we see on the Court of Appeals. But we all work together and reach consensus because we bring that experience to the bench. We don't base our decisions on personal beliefs, but rather on our oath to follow the law and to rule without bias. I was trained as a mediator for 10 years, the last 2 years of my practice. That has been helpful in working with other judges. Again, sometimes it requires some compromise, sometimes you have to rewrite, sometimes you have to write a dissent, as the Supreme Court candidates talk about. But we work well together, we respect one another, and I remember, I believe it was Justice Scalia, who's been quoted here tonight, famously said that you really can't understand what it is to be a judge until you have to write an opinion that goes against your personal views. You have to follow the law. And I fully understand that now, having been a judge for a year, and that's something that I think the public needs to understand as well.
Thank you. And I will ask the same question to Mr. Winter. As a member of the three-judge panel, how will you work with the other judges when one or both disagree with your opinion in the case?
The key thing in resolving any dispute, whether it's on three-judge panels or any other aspect of law, is communication. One must be able to approach the other judges. Hopefully consensus is reached because it's in the public interest for a unified three-judge panel to render a decision. It's well reasoned. As the question says, sometimes that's not done. We all have different experiences and background. Mine happens to be accounting, taxation, finance, labor, construction, and claims medical malpractice. Sometimes we do our best to resolve the dispute orally. When we worked for Judge Bertelsmann and when he was sitting about designation on the Sixth Circuit Court of Appeals, the judges would circulate draft opinions. One would generally prevail, sometimes they don't. And when there's a clash of views of the law, that occasionally happens, we forcefully but respectfully deal with the draft opinions and come up with an opinion of the court, which means two, but generally two of the judges view one way and the dissenting opinion views the other way, and each side will have the opportunity to critique the other's decision. Like Mr. Fisher said, dissents are important, and they may change the law down the road. But the important thing is to communicate among the judges, to get an opinion, if at all possible. If not, to give well-reasoned opinions that address concerns of the dissent.
Thank you. And we'll start our final round of separate questions for the separate groups, and we'll have a couple for everybody. But our last Supreme Court question, and I think it's Ms. Keller's turn to go first now. The Kentucky Constitution includes a single subject rule, which states that no law enacted by the General Assembly shall relate to more than one subject. What methods should a court use to determine whether a state law relates to more than one subject?
How about common sense? A single subject law is about one thing and everything that pertains to that one thing. A law can have separate propositions within it or subparts within a statute or a statutory scheme, but it should be about one topic. And this is important because as the third branch, we're interpreting the laws and the bills as they come forward from the second branch. I think part of this question is probably aimed at, we do not want a smaller subpart of a law or bill to be attached to a larger law or bill that has absolutely nothing to do with pensions, for instance. So it's pretty obvious to determine what the subject of the law should be and what pertains to that. So it was Chief Justice Palmore, I believe, that said common sense should not be a stranger in the house of the law. And I think this is the common sense meaning of the plain text of the bill as it comes forward. And, we really don't want unrelated topics tagged together and becoming laws for us to later have to interpret, but sometimes that does happen. So I think it's a pretty straightforward analysis.
Thank you. I'll ask the same question to Mr. Fisher. The Kentucky Constitution includes a single subject rule, which states that no law enacted by the General Assembly shall relate to more than one subject. What methods should a court use to determine whether a state law relates to more than one subject?
Well, I couldn't agree with Justice Keller more than using common sense in this situation. But unfortunately, the single subject rule in Section 51 of the Constitution has a loophole that the General Assembly can drive its whole agenda through. It says that no law enacted by the General Assembly shall relate to more than one subject, and that law shall be expressed in the title. So if someone claims that Kentucky law relates to more than one subject, the court must inquire as to whether the title of the bill encompasses the subject matter of that law. If the court finds that the title of the bill is broad enough to cover the entire subject matter, then the law meets the single subject requirement of Section 51. The court might also want to review the legislative record to make sure that the bill title was in fact adopted. Because in the last parts of the legislative session, there are a lot of amendments to a lot of different laws pertaining to different subjects that end up being in one bill. So they have to look to make sure that the legislature has adopted the proper title amendment to encompass all those subjects. But frankly, if the General Assembly is creative enough to draft a broadly worded title, it follows its own rules with respect to adopting that title. The court is limited in its judicial review on a claim of a Section 51 violation.
Thank you. And now we'll do our last question. It's just for the Court of Appeals candidates. And I believe it's Mr. Winters' turn to go What Kentucky Supreme Court majority opinion has particularly influenced or impressed you? Please describe the case and tell the audience how your work has or will be influenced by the court's opinion.
Sure. One of my favorite cases is the case called Bull Fiscal Court versus Bull County Board of Health, a 2014 case. And it addresses reining in bureaucrats and bureaucracies so that they are not the fourth branch of government. Rather, they have to keep their regulatory powers canalized within the charter statute in which it operates. You all may remember back in the day when we had the debate over whether smoking can be held in public places or whether it should be banned. In Bullitt County, the Bullitt County Board of Health took it upon itself to enact a regulation that banned smoking in all public places. And the Bullitt County Fiscal Court and several private restaurateurs sued the Bullitt County Circuit Court to strike down the board's regulation, which they were successful in doing. The board took the case to the Court of Appeals, and the Court of Appeals ruled that the statute and the actions of the board were constitutional, and it was within the power of the board to ban smoking in public places. It went up to the Kentucky Supreme Court, and they ruled that the board had gone too far. It did not have the power under the charter statute to totally ban smoking in public places. That was deemed to be solely a legislative function, and consequently the regulation was reversed. That applies to me that we need to watch administrative regulations and how they are enacted and how they are applied. Our General Assembly enacts statutes, and they are to be construed, their charter statutes are not to be construed so broadly as to grant administrative agencies the power to adopt what are essentially statutes and regulate in that manner.
Thank you. And I'll ask the same question to Ms. Trullo. What Kentucky Supreme Court majority opinion has particularly influenced or impressed you? Please describe the case and tell the audience how your work has been or will be influenced by the court's opinion.
I may be showing my age a little bit here with the selection I made, but I graduated from Chase in 1984. And right after I graduated, and I learned all about tort law here at Chase, the law changed dramatically in that area with the case of Highland v. Hayes. For those of you who are non-lawyers, that case arose out of a lawsuit filed by an injured person riding in a vehicle, somebody who was clearly negligent. But that passenger knew or should have known that her driver was under the influence. Under the law that had existed for over 100 years at that time, that passenger could not recover anything because of her comparative or contributory negligence. And in 1984, with that decision, the Supreme Court, Kentucky Supreme Court, said the law on occasion has to evolve and adapt to keep up with changing times. And with that decision, the Supreme Court brought Kentucky in line with 41 of the 50 states that had recognized that you should go to a jury to determine if someone can recover only a small percentage of liability. So that opinion changed the law dramatically at a time that obviously had a huge impact on me to respond to the question, because I was working for the Court of Appeals, and then we had to deal with all the cases that came out after that, trying to figure out how juries should be instructed and how the law should be applied. also became significant when I left the court and went into practice primarily as a litigation attorney handling personal injury cases. It's still significant today because of what it has done with personal injury litigation. But it's also very significant because it illustrates the Court of Appeals had to follow stare decisis. We had to follow precedent, and the Court of Appeals at that time did not change the law. Only the Supreme Court can make that change on a law that had existed for 100 years. The Court of Appeals is not a court. The professor indicated that makes law.
Thank you. Okay, so that's the end of the portion of the program where we're asking different questions to the Supreme Court candidates and the Court of Appeals candidates. And now I just really have two questions that I'm going to ask to every candidate. And I think I will start on both of these questions with the Court of Appeals candidates and then give the Supreme Court candidates the last word on that. So that means, Ms. Citrullo, it's your turn again now. First. So the first question for everyone is, what is your approach to judicial decision making?
My judicial decision-making approach is made up of all my life experiences as an attorney, as a mediator, even as a mom. I think I have the ability to see things fairly and independently. I have the ability to be objective. I have the experience of trying cases for years, which is very important because we're reviewing in the Court of Appeals cases that have been tried by judges or juries. It's very important, though, that the public understands, and I alluded to this in an earlier question, that we are bound by stare decisis. We cannot substitute our opinion for the trial judge because something based upon comments that have been made throughout this campaign that my opponent hasn't fully understood, that we are absolutely looking first at the standard review. Was it manifestly unjust? Was it clearly erroneous? Was there an abuse of discretion by the trial judge? If those things aren't there, then we have to uphold what the trial judge did or what the jury did. We do not retry the case in the Court of Appeals. I want the voters to understand that judges have to follow the rules, and that's what I've been doing in this court. And once you take that oath to follow and uphold the law, then I think you have a better understanding of the limitations of being a judge.
Thank you. And is there a technical issue?
Yes.
Okay. Keep going. Okay, then I'll keep going. So, Mr. Winter, I'll ask you the same question if you're ready for it.
The green light's on.
Okay. So, Mr. Winter, the question is, what is your approach to judicial decision making?
My approach is, as I've indicated throughout this campaign, is to be conservative, fair, and impartial. And what I mean by conservative is in construing and applying the law that's before me. It's the law that's adopted by the General Assembly or your city council, depending if that applies, or the fiscal court, or the stare decisis that's been decided by previous decisions by Court of Appeals and the Supreme Court. The decision does not depend on your political persuasion or your opponent's political persuasion. It doesn't depend on what I think the law ought to be or what the decision is. You have the law as I've discussed on your side, and if the facts of the record are before you, you will have my vote every time. That's just the way it is. The thing that got me in the race is judicial activism that has no place in Kentucky courts. We don't legislate from the bench, we decide cases. And it's based on the law that I've enumerated.
Thank you. Now, I will ask the same question to the two Supreme Court candidates, and I believe it's Mr. Fisher's turn to go first this time. So, Mr. Fisher, what is your approach to judicial decision making?
Well, as said before, it's a common sense approach. It's a traditionalist approach, I believe that most judges will render the right decision if they ascertain the facts and apply the law before rendering a decision. The outcome of a case is not prejudged before the facts and the law are analyzed and applied. I would use the system read, research, reason, and write. That's, you read the record and the briefs, you research the law, you reason and reach your decision at that point, and write your opinion. I'll add a few personal nuances to that approach. I will review the record of each case, apply the facts of the law as written, not as I would have written the law myself. I'll approach each case with an open mind, with an impartial attitude, fearless determination, a humble demeanor, and a steady temperament. I'll take a restrained approach to the process of judicial decision-making that is respectful to the proper roles of the other branches of government. I'll render decisions promptly and write them clearly so that justice is neither delayed or misunderstood. I'll support and follow the constitutions of the United States and Kentucky in every case, as the oath of office requires.
Thank you. And Ms. Feller, I'll ask you the same question. What is your approach to judicial decision making?
It sounds simple, but it's hard to do. We have to put our personal preferences and biases aside every time we make a judicial decision. That's the most important thing that judges do. Judges have to have experience and competence in the law in order to have the tools intellectually to apply to the facts before them and apply the law only to those facts, even when that result is something that the judge personally, even vehemently, disagrees with. In the 16 years that I've been making judicial decisions, there have been many nights that I have walked or tossed and turned over the decision that I was called upon to make. But I took an oath, and it references both the Kentucky and the United States constitutions and the laws of both the Commonwealth and the United States. And it's a sacred oath to apply those. And so that is what a judge does every single day. It's been mentioned that judges should not legislate from the bench. I couldn't agree more. It's kind of an absurd phrase because judges do not make policy. They rule on the case before them. But judges also have to have experience in the law and maybe combined experience in life to know when there are some nuances brought to the table in the interest of compassion and in the interest of justice. We are here to do justice, as my colleagues have noted around the table in the conference room at the Supreme Court, and that is what we do. But it is never guided by our personal preferences, or most importantly, our personal positions on any issue that might come before us, whether it be political or otherwise. When judges wade into public debate or run for office on the platform of their personal position on any particular political issue, then we run the risk of having judges that do legislate from the bench. And so the hardest thing about judicial decision-making is really the simplest concept, being fair and impartial.
Thank you. Now I'll ask this will be the last question, and this one, the candidates are welcome to take this one as really their invitation to make a closing argument or a campaign speech of sorts. And the last question, and I'll be starting with Mr. Mentor this time. What skills or qualifications do you have that make you a good candidate for the judicial position that you are seeking?
I have 38 plus years of training, education, and experience in the practice of law, and most recently in appellate court practice. I graduated from University of Louisville, magna cum laude, in 1983. I clerked for our federal district court judge, William L. Bertelsman, who taught me how a court is to be run. In his aside, he sat on the Sixth Circuit Court of Appeals by designation. I saw him in action, and he showed me how appellate court decisions were made. From that time, I've had, as I said, 38 years of trial court and appellate court practice. In the last 5 years, I've practiced almost a great deal of time, not exclusively, in Kentucky's and Ohio's appellate courts. I've practiced approximately 160, at least 160 cases to a decision. Part of what I'm really proud about is for 10 years I've been rated AV1 preeminent by, in terms of judicial and in the judicial decision, for the last 10 years. I've been rated that way by Martindale Hubble, which is a national critical peer review entity. They review my performance based on the judges that I've appeared in front of in practice, and also the opponents that I've knocked heads with, and they've evaluated me highest in terms of legal ability and legal ethics. And I'm just really honored to be 10-year AV1 preeminent judicial edition by Martindale Hall. Last thing I'd like to throw in is I've indicated that I was a naval officer. I served aboard a fleet ballistic missile nuclear powered submarine, and I also served on the Navy's F-14 fighter program. And while, of course, that doesn't have much to do with law other than Navy procurement practices, it taught me a lot about personnel, how to interact and manage and supervise people, how to budget, how finance works. And all these training education experiences, legal and non-legal, come to a spot in my life. I'm prepared to serve the public once again as a judge of the Kentucky Court of Appeals, and I ask for your vote on November 8th.
Thank you. And I will ask the same question to Mrs. Trula. What skills or qualifications do you have that would make you a good candidate for the judicial position that you're seeking?
Well, as I said earlier, I've been a trial attorney, I've been a family law attorney, small business owner for 30-some years. But before that, I worked for this court, for the first woman ever on the Court of Appeals. My mentor, Judge Judy West. Back then, judicial diversity and economy and sizes, so we've come a long way. And I am only on the Court of Appeals now because I was recommended and encouraged to apply for that position when it became open last year to fill the vacancy in the court that I love so much. I applied along with 15 other people to a bipartisan statewide committee, and I was selected and then appointed by the governor last year. What I bring to the court is that experience working for the court for 7 years and then working as a busy practicing attorney for 32 years. And now on the court, I've been doing the job for a year. I'm honored to have been supported by over 450 attorneys, retired judges who know my work ethic and my skills, county attorneys, Commonwealth attorneys, and court personnel across all 13 counties. I think people who know the judges and know the attorneys know what we need on this very important court. I'm honored to have been recommended by the Northern Kentucky Institute of Judiciary, again, a bipartisan group that's just looking out to make sure that we have excellence and fairness in the courts. I have endorsements from law enforcement, statewide people know that we want judges who are knowledgeable in the community, who are fair and impartial, and have the right reputation and experience. And that's why I'm here, and that's why I'm asking for your vote to stay here on the Board of Appeals.
Thank you. And now I will turn to the chief candidates for Supreme Court and ask them the same question. Starting with Ms. Keller, what skills or qualifications do you have that make you a good candidate for the judicial position you're seeking?
Thank you. And thank you to the leaders and the owners and the College of Law, as well as the Northern Kentucky Forum for providing us this opportunity tonight. I'd like to begin by saying I'm honored to be the first woman to hold this seat in the Kentucky Supreme Court. I'm also honored to be the first Chase alum elected to the Kentucky Supreme Court. Those are two important things to me. I think the answer is a combination of legal experience and life experience. Life experience, I'm a former VA nurse. I worked in the intensive care unit. I worked my way through the night program here at Chase. I've been married to Jim Keller for 36 years. He'd be here tonight, but he's campaigning for me in another county tonight. Although our two adult daughters are here, and they are accomplished professionals in their own right. I'm proud of my family. Legal experience, 32 years of legal experience. 17 years as a practicing lawyer, which included service as a prosecutor, and then nearly 16 years service on the bench between the Court of Appeals and the Supreme Court. I've written nearly 1,000 opinions during that time, and I'm proud of my record. I also think that judges need to be courageous to do the right thing, apply the law to the facts. In our Supreme Court, has been called upon to make many consequential decisions in the past few years, and the court has stepped up, and I've stepped up. And I'm proud of the record of our court, and I'm proud of my service on it. Of course, we've talked about fairness and impartiality, and I have a reputation for that, and a reputation for integrity among the members of the bar and among the judiciary. I'm endorsed by the Fraternal Order of Police statewide and unanimously among my district, as well as the Board of Kentuckians for the judiciary, and also many practicing lawyers and retired judges. I'm proud of those endorsements. I'm proud of my record of service. My service as chair of the Kentucky Access to Justice Commission. What we do is provide access to the courts for those among us who are disenfranchised for economic or other reasons, and allow them to have access to our courts. The Chief Justice has shown his confidence in me by appointing me not only as chair of the Kentucky Access to Justice Commission, but also as chair of the Criminal Rules Committee of our court. Our court does all the rules, criminal, civil, Supreme Court, ethics. We are in charge of all of those rules, and that's a pivotal part of what we do. I will say that even though we've talked about weighty constitutional cases here tonight, the bulk of what we do at the Kentucky Supreme Court is we're the people's court. We hear criminal cases, all matters of civil cases, family cases, workers' compensation cases. And so it's crucial that your judges and justices have experience in the practice of real law, so that when they're looking at what happened in the courtroom or in the administrative hearing or whatever it is they're reviewing, they understand and recognize what it is they're looking at. The constitutional questions do come, the questions where we have to adjudicate between the other branches of government, but they pale by number in comparison to what we do day to day, which is really the disputes and settle the affairs of the citizens of the Commonwealth. It is the greatest privilege I have ever had professionally to serve as your Supreme Court Justice, and prior to that, as your judge on the Court of Appeals. There is nothing more sacred than the oath that I took to defend the constitutions of the United States and the constitutions of the Commonwealth. So I take my life experience as a nurse, as a wife, as a mother. I couple that with my legal experience, both in the courtroom and on the bench. And I ask that the voters remember to look at the nonpartisan part of the ballot on November the 8th or before, if they vote early. And I respectfully request to be returned to the court that I love so much, the Kentucky Supreme Court. Thank you.
word goes to Mr. Fisher, and I'm going to ask you the same question I've asked everybody else on the stage. What skills or qualifications do you have that make you a good candidate for the judicial position?
So after 40 years in the legal profession, I bring a broad and diverse skill set and legal experience to this job. A few candidates for this position can claim that they've successfully litigated constitutional matters in the Kentucky Supreme Court and also represented corporate clients in bankruptcy courts in Ireland, Great Britain, Australia, and France. So to my knowledge, no other Supreme Court justice has experience drafting laws that protect teenage girls from predatory rapists and from fentanyl traffickers, while at the same time being able to draft software licenses, closing commercial real estate deals. I have served on the House Judiciary Committee for 2 decades and helped shape the penal code over that time. I've litigated and legislated some of the most politically volatile and constitutionally important cases and laws in Kentucky history. I'm endorsed by every pro-life organization in Kentucky, and I'm the first man to have received the Torchbearer Award from the Susan B. Anthony list. Look, I understand that many trial lawyers don't think that a legislator has the right kind of legal experience to serve on the bench. But folks, we have a real constitutional crisis in Kentucky. We have a court that has ruled that the governor has inherent constitutional powers to shut down schools, churches, and businesses. So maybe it is time to elect a person who will respect the equal role and work of the General Assembly and who can restore the balance of power among the branches. That's the kind of knowledge and experience I bring to the Supreme Court, and I humbly ask for your vote.
Thank you. For all of you invited you to come to the reception, I had asked you at the beginning to withhold any applause, and I'm just going to ask you to do that for one more second, but then to stop withholding your applause. But I would like to first thank all our sponsors, NKU's Chase College of Law, the League of Women Voters of Northern Kentucky, and the Northern Kentucky Forum. And then I would especially like to thank the 4 judicial candidates who agreed to participate and who've done such a wonderful job today. Robert Winter Jr., Suzanne Citrullo, Michelle Keller, and Joseph Fisher. And now you don't have to withhold your applause.
Amen. Thank you all for your attention. Travels with John Stephenson, 859-750-0000. God bless you and have a great day. Join us on Facebook and YouTube. Former Superintendent of Education, Commonwealth of Kentucky. Get you there on that one. And now tell me your name starting right over here.
Linda.
Huh?
Linda.
Linda?
Ken Catkin.
Okay.
Pam.
Pam.
Adrian.
Nice to meet you all. And this is your husband.
Yep.
And she's the smartest move you ever made. That's right, just like my wife's the smartest move I ever made. Now, God bless you. And my wife's name is June Guyman Stephenson. And every time you come to Campbell County, every time you turn a rock over, you find another Diamond Guyman. Large family. Gotcha.